Welcome to a high-stakes family court showdown, where Judge Wallace faces one of the most emotionally charged battles in the system, child custody. With accusations of manipulation, mental health concerns, and parental misconduct, the courtroom quickly becomes a battlefield. But at the center of it all, the innocent children caught in the crossfire. Judge Wallace makes it clear his top priority is shielding those children from harm.
In this intense family court hearing, Judge Wallace grapples with a heated custody case involving serious accusations between parents. The attorneys clash over inappropriate notice, mental health concerns, and child manipulation. Judge Wallace stresses the importance of shielding the children, issuing a strict no-contact order regarding case discussion. He warns both parents violate this, and jail is next. With therapy, guardian ad litem concerns, and disputed discipline tactics, the case is now set for a critical hearing on July 18th.
Your Honor, this is Ms. Duke's motion to continue. I don't oppose it. We just need a date to reset it.
Are you available the 14th?
14th of July.
I can't set anything up.
Okay, that's all right. Well,
You can't say anything else on the.
that's when I had originally said it, and they told me I could set it that day. I still had it down on my calendar. I had it on both.
Apparently, Judge Wallace has advised he cannot say anything else on that day.
In the future.
Okay.
You need another day?
We do need another date just to set it in case we can't agree, but I think we'll probably be able to reach an agreement on it.
I don't think Ms. Roberts is available in August, the date that we have.
On the August dates, those are double dates, and I've already got everything set.
September 3rd.
You also have a Jones versus Jones case that's next, and you have a motion to continue in that.
I do.
Yes. And
Here the defense raises a crucial legal point: inappropriate notice. Under civil procedure rules, attorneys are entitled to 5 business days' notice before a hearing. Failure to comply can justify a continuance. But beyond the paperwork, deeper issues emerge: therapy for traumatized children, accusations of threats from the father, and alleged badmouthing by the mother. The stakes rise fast. This isn't just about scheduling dates.
our only issue, and I don't know if Your Honor reviewed the motion, is the mental health of the minor children. It'd be the only reason that we would need to
What's your
press
reason?
forward.
I haven't looked at the file yet. What's your reason for a continuance in that case?
Well, there was 2 reasons. Number one, inappropriate notice. We got it on Tuesday. Under the rules of civil procedure, we're entitled to 5 days notice, 5 working days notice. We were not provided 5 working days notice. I got it at 5:03, emailed to me. And again, just getting ready for it. Ms. Duke has made some accusations that are going to take this will be an all-day hearing.
If I may briefly respond, it was sent by certificate of service on the 18th, and so we complied with the rules of civil procedure, and then I also emailed it at 2:00 on the 23rd.
So we
what are
emailed 3 days.
your issues regarding the urgency of it, Ms. Duke, in the Jones case?
A few of the minor children are going to have to be in significant therapy based on the continued threats of the father and the bad mouthing of the mother and some things that he's doing to try to manipulate the children.
And that's
The
contested.
children are here if Your Honor needs to hear from them.
And again, the second reason is I had a deposition scheduled with Ms. Duke's law partner at 11:00, but late Friday afternoon, Mr. Vandervoort filed a motion to continue, and we heard that in front of Judge Turnbow, and he granted the continuance. So that was the other reason for the continuance in my motion, but that resolved itself. But it did lead to the fact that I got this and had no time for preparation, and so we just need to continue.
What about,
When Judge Wallace discusses new possible dates, the atmosphere shifts. Attorneys juggle crowded calendars, competing obligations, and overlapping counties. But pay attention here. Behind the procedural shuffle lies a strategic battle. Every delay favors one side or the other. One attorney wants more time to prepare. The other insists on urgency for the children's safety.
What about the 9th of July?
The 9th of July, I have Judge Lockhart Mashes in Dixon, and I have
I'm
Carbone versus
thinking is give you
Carbone.
a date for both of these that you may
Bugle.
have to hear it out of county because someone else will be here in July.
Judge, may I approach off of the video?
Mute this, please.
I don't like for everybody to know that I'm going out of town from the 5th through the 12th of July.
That was the reason we were moving Butler.
Yes.
18th.
18th of July.
This is all contingent upon you agreeing to hear it out of county because I'm going to be in Cheatham County, but I have that date available. And other than that, I could give you the,
As far as I know, I try to keep Fridays
I could
open.
give you the 29th.
The 29th, again, that's Judge Lockhart Mashes, Dixon, Chancery, and I have a Bradford versus Bradford, and then a final hearing in a Crispin
Would you
versus.
rather hear this one on the 31st and just bump to the Bates case?
Now, I can do the 18th. I don't know that one's due.
I have a matter that the Hickman County Court set, but I will file a motion to continue on that one. So I can do July the 18th. It's important that this be heard.
And we're doing Butler mediation on the 16th of July. So hopefully we can get a date on it. We'll just work together to get a date on it after the mediation.
All right, so at this point, we're gonna set the Jones case that Ms. Roberts is asking for a continuance on the 18th of July.
Yes, and can we admonish both of the parties to verify that nothing is to be said about this? That is our major issue. The kids are calling and crying, and we would assert that we've got text messages to back up everything that's been said in our motion.
I'm not gonna assume the facts in the case. Are the parents here, both sides?
They are.
Bring them up.
The judge lays down a strict no-contact order. Neither parent is to discuss the case with their children. This is a pivotal ruling. Why? Because children are highly impressionable. If one parent badmouths the other, the kids can be manipulated into loyalty conflicts, emotional distress, and even permanent estrangement. Judge Wallace doesn't mince words, violate this order, and jail is next. Viewers, imagine being told you could lose your freedom just for talking to your own children.
Will, keep your hands out of your pockets, please.
Mr. and Ms. Jones, we're moving heaven and earth to get you a date to hear this motion that's been brought up, and there have been allegations that have been made by both sides about the situation. I'm not assuming that any of those facts are true, but what I'm going to tell you is this. I'm putting an order down today that you two are not to discuss this case with the minor children, period. You know, is there a guardian ad litem in this case?
I think we need one at this point, Judge.
I'm not opposed. I don't know that there's funds available to do it. It's a private case, but if we're never opposed to one, that's fine. We would just ask that both parties be ordered to make a deposit with that guardian ad litem up front.
Well, the reason the guardian ad litem is even being discussed is because of the fact that you've got minor children in the middle of this. You both may be fine people. You both may be good parents in your mind, and that's good. But my main concern and the main issue that I have in this case is to protect the best interest of the minor children. So if that causes me to have to come down hard on one of the two of you, so be it, because my interest is trying to protect the children. But by the same token, children are very perceptive and empathetic to their parents. And if they see one of their parents upset about something, then they naturally will, try to side with that parent, and they will naturally try to empathize with that parent. So let's try to shield the children from whatever's going on between the two of you. Let's don't involve the children. And I say it in a very nice way, but I'm telling you, I'm ordering you not to involve these children and not to have the children influence, not to discuss this case with you about this. If they have questions about it, you just tell them, honey, I can't discuss it with you because that mean old judge told me he put me in jail. You don't have to say it like that, but that's exactly what will happen. If I find out that you two have broken my order, then I'm going to put you in jail, because I fully and firmly believe it is in the best interest of your children not to be put in the middle of this situation. Children are, used to having both parents. That's the home environment they had, and now that's blown up. Why wouldn't they be upset? I mean, that's a natural reaction to the fact that what they thought was their cocoon of protection and the home that they had is now no longer there, because their parents can't get along, and they're going to go through a divorce. But under the circumstances, you two can still make it okay for your children by protecting them from being exposed to all of the negativity that a divorce naturally brings about. Allegations may be made. Those allegations would have to be proven in court. I understand that children may be called to testify. I think that's a very regrettable, but sometimes a very necessary step to be taken. But that's the reason that I'm considering a guardian ad litem being appointed, is the fact that the children need somebody to advocate on their behalf. Now, Mickey Furlong Smith is the one that I generally use in a lot of cases. I would simply suggest, since I've set this hearing for the 18th, that you two need to check with her and make sure she's available. Before, I know she's out of town
She's
right
in
now.
Chicago right now.
So it would be my opinion that you need to check with her and see if she's available on the 18th. If not, we need to get somebody else that is available.
Yes, sir.
And there are other individuals who can do that. Lynn Coffinberry is another one that we use on a regular basis. But let's find a guardian ad litem that's available on the 18th so that we can do
Yes,
this.
sir.
Where are we going to hear this? Which courthouse?
Courtroom 5 in the Justice Center,
In Dix. Okay.
Charlotte, Tennessee.
You just said you were in Cheatham, but where you're going to be in Dix.
Right.
And again,
A surprising twist: the debate over cell phones as discipline. In today's digital age, taking away a phone is often more powerful than grounding or corporal punishment. Judge Wallace supports the practice, calling it a legitimate form of discipline, far preferable to the belt whippings of older generations. But the deeper conflict is clear. One parent accuses the other of seizing phones to silence the children from revealing home life details.
just some guidance, Your Honor. Again, as you are well aware, children and their electronics this day are something that I didn't necessarily grow up with, but punishment issues when you're taking electronics away from children because of misbehavior, whatever, does that include cell phones? And then escalates into, oh, you've taken my cell phone away from me.
My client doesn't have a problem with that at all.
So again,
But if she's explained to the children, if you've done something, Dad can take phone away. Yeah, absolutely.
Put it in the court order that one of the avenues of punishment. How old are these children?
they range.
We've got 16 and 11 right now.
Well,
There's a set of twins.
I'm of the opinion that if they are misbehaving and there's some reason to do that, taking their cell phones away is better than having a leather belt across their rear end like my father used to do with me. So I think that would be certainly permissible, and the children need to understand that is not an abusive exercise of parental authority.
And go call the other one on somebody else's cell phone and say, somebody took my cell phone away, and I made
Just put it in the court order that the court authorizes both parents to take the children's phones away if in an appropriate situation as parental discipline.
I will assert with the court that my client has absolutely no problem with that, but it was discovered that one of the children was confiding what was going on in Dad's home, and that's when the child's phone was taken away.
And that is highly disputed with some, and again, that's what they want you to believe, Judge. And I know you're not listening to that, and that's why I ask in a generic sense. I'm not trying to prime the pump that Ms. Duke is trying to do. It's disputed.
You two are good lawyers, but you.
As the lawyers spar, Judge Wallace compares them to oil and water. It's a rare moment of candor that underscores the tension in the room. Both attorneys are skilled, passionate, and utterly opposed, a reflection of the parents themselves. This isn't just a legal clash. It's a collision of personalities, strategies, and raw human emotion. And through it all, the children remain the silent witnesses, their futures hanging in the balance while the adults fight for control.
Kind of like oil and water. And under the
Good
circumstances,
and bad. I realize that, Judge.
it is yin and yang. Is that what you said? And there is some truth to that, whether you like it or not. But under the circumstances, I'm not assuming any of those facts are true. I'm trying to give you an opportunity to be heard where we can establish what the facts are. So let's just try to maintain the status quo and keep the children protected to the best of our ability until we have that hearing.
Yes,
All
sir.
right. Thank you.
Thank you.
Thank you, Judge.
And so the stage is set for July 18th, a critical custody hearing that could reshape the lives of an entire family. With a guardian ad litem likely to be appointed, therapy underway, and strict orders in place, Judge Wallace has drawn the battle lines. Will the parents comply, or will emotions spill over into contempt and jail time? One thing is certain. In this courtroom, the judge's gavel isn't just about law. It's about protecting children from the fallout of their parents' war. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.